Yeah, I think now you're streaming on YouTube also.
Okay. Shall we start? Okay. So, hello everyone, and welcome to our third panel of the CDR panel discussions of 2021 on the theme of Women in Arbitration. I am Noel Hind, a law lecturer at JGU and a CDR member. Today we will be discussing an important and persistent topic in the judicial and dispute resolution system in general, but more specifically in arbitration. The reason why this topic is, or has been really, at least relatively well discussed and hot topic, is due to the fact that arbitration, out of all other alternative dispute resolution mechanism, and even in relative to domestic judicial systems worldwide, is considered to have the lowest woman representations. In our talk today, we will try to underline several aspects and grounds of gender role and how it affects women or even any non-male practitioner career in arbitration, whether she's a lawyer, arbitrator, or even an expert, starting from how gender affects women arbitration appointments, whether by the parties or arbitral institutions, how the leak pipeline practice, which we will further define in our talk, or unconscious discrimination lead to a dearth of women or to be more precise, really a dearth of active women in this field. So this and more will be discussed in our event with our honorable speakers. Today, I am really extra delighted and excited to discuss such, and I won't say timely because really it has been there for decades now. So I'll just say such a persistent topic with two powerful and inspiring women in our field whom I had the honor to learn and work with, both in ICC members, yet from diverse legal and cultural backgrounds, which in my opinion is the missing element in this conversation. One who've been practicing mostly in the US and another in Jerusalem, Palestine. So without further ado, allow me to introduce our speakers. Professor Catherine Rogers, who has taught me personally at Pennsylvania State University, and really the reason of my practical specialization in this field, is a professor of law at Bocconi University and has a dual appointment at Queen Mary University of London, where she also co-directs the Institute of Ethics, Regulation, and Commercial Law. Her scholarship focuses on the convergence of the public and private in international education, the intersection of markets and regulation in guiding professional conduct, and on the reconceptualization of the attorney as a global actor. Professor Rogers is a reporter for the American Law Institute Restatement of the U.S. Law of International Commercial and Investor State Arbitration. Among her research projects, Professor Rogers co-chaired the ICCA Queen Mary Task Force on third-party funding in international arbitration and is the founder of Arbitrator Intelligence, a global information aggregator and legal tech startup, which I am sure today we will touch base on more than one time since it is relative to our topic. And of course, lastly but not least, arbitrator and advocate Lubna Katibeh, who is the managing partner of the arbitration firm I personally worked in. Advocate Katibeh is an ICC member and co-founder and managing partner of Equity Legal Group. Ms. Katibeh works in areas of banking, finance, alternative dispute resolution, litigation, contracts, and consultations, mainly in business. Ms. Katibeh is the first appointed court member in the International Court of Arbitration representing Palestine from 2012 until 2015, and reappointed for the years between 2018 until now, elected and appointed as a commissioner in the Board of Commissioners at the Palestine Independent Commission for Human Rights, appointed by the President of Palestine as an independent board member representing the private sector in the Palestine Electricity Regulatory Council. She was previously working as deputy chief of party to the European funded project for empowering Palestinian judiciary. Ms. Katbe has been a legal counselor for many local and international companies, as well as head of the first local arbitration center in Palestine. Ms. Katbe lectured at the Birzeit University Institute of Law in the topics of ADR and drafting legal documents and contracts between the years 2012 and 15 in the professional diploma program for legal counselors at public institutions and ministries. As true believer in empowering women in business, Ms. Katba is a member of the MENA Arab Women Legal Network and the Businesswomen Forum. Supporting women and children in Palestine, Ms. Katba is an active member of the General Assembly of Financial Usra Society and member of the board trustees at Dar al-Tifl Arabi in Jerusalem. So I'd like to start with allowing our speakers first to present a brief background or story of their careers, where we'd be able to get glimpses of how gender has affected their journey and how perhaps it's uh, manifested differently with other factors like age background for a woman or the level and advancement of their careers. After that, I will direct some questions to both our speakers in order to further enrich our discussion. And lastly, we will open the door for any questions or commentaries from the audience. So without any further ado, Professor Rogers, again, we are delighted to have you with us. Would you please give us a summary or a short story on your career journey in arbitration as a woman?
I think Professor Rogers might have faced a technical difficulty because she's not on this meeting. Maybe you can start with
Of course,
Kadba and
of
then
course.
contact her again. Yeah.
Of course. So Professor Lubna, I think that question is now for you. Would you please share your career journey in arbitration as a woman, but not just a woman who happens to be the first arbitrator in Palestine and working in the MENA region in total as well?
Thank you, Noel, for this wonderful introduction, and thank you for the Center for inviting for such important topic, really to be discussed among women, among arbitrators, and among legal professionals in general. To talk about arbitration is really taking so many different perspectives. To start with, I should say that until recently, it was not common to be a professional in arbitrator per se, or only doing work as an arbitration lawyer or as an arbitrator. If I recall, when I studied at the university a few decades ago, there was no arbitration course even. It might have been an elective course that we did pass through or did not pass through. Personally, I don't remember that I did have any introduction to arbitration per se as an undergraduate student. Thereafter, when you start your career and your profession working with a law firm or different institution, you get introduced more and more to this concept, but still from a very, very narrow angle and perspective. Personally, it was for me until I had to work in a project that wanted to promote arbitration in Palestine. And they said, wow, okay, I read about the topic, but then it's only mere theoretical reading. So at that time, I have been graduated from Queen Mary in banking and finance, and they offered a wonderful, wonderful diploma in international commercial arbitration. So I said, okay, step one, I want to go there. So I did my second LLM or postgraduate diploma in international commercial arbitration. And that was for me the starting point to start entering this field. I don't want to say having expertise or having real knowledge, but at least knocking the door in the field of arbitration. We started by establishing the first arbitration center in Palestine. We called Tahkim. And this really involved huge work, which introduced us to so many issues in arbitration. It started from drafting the rules, the procedures, having a pool of arbitrators, mediators to work with you, and introducing it to the private sector in Palestine. Therefrom, I started as a lawyer, getting engaged more and more in the arbitration field. But to talk specifically about the issue of today's encounter, which is women in arbitration, I should say that personally, women arbitrators and practitioners in that field gave me a huge, huge impact in this field. And to start with is maybe Professor Catherine Roger, who is really a great friend, a great colleague, and whom she and I started almost 11 years ago, introducing international arbitration in Palestine, and thus introducing a wider perspective of arbitration to Palestinian community and to Palestinian lawyers. But knowing Catherine really opened much more than just international arbitration. Knowing her, being connected through her to a wider community of arbitrators, lawyers, institutions, law firm, this is what makes an impact, and this is what makes a difference when a arbitrator really supports a co-arbitrator or a colleague arbitrator. And as you said, Noel, I've been the first woman to be appointed in the Court of Arbitration in the ICC in Paris. And I remember the first time I was there, also around 10 years ago, knowing a person such as Mireille Philippe, who was leading or a founder of Arbitral Women, and having her like guiding me the first day at ICC and introducing me to that world of ICC and that world of arbitration is really, again, a huge support and a huge advantage for a person who is really starting to know, for example, more and more about international arbitration or being representative in such an international institution. Knowing other colleagues, like my colleague, advocate Nadia Darwaze, who was also a Secretary General in the ICC, but then working at JAC, the Jerusalem Arbitration Center, and who is a prominent lawyer in different law firms in Paris. Again, only makes better connections, better introductions to this world, and better support. I remember through Catherine, I could nominate international arbitrators in one of my international cases. I remember with Nadia, I could work as a co-lawyer in an international arbitration. So to make the long story short, this is what I'm trying to say briefly. It is very important that women arbitrators, women professionals support women in this field. It's not only the gender that makes you a good arbitrator, the gender that makes you be appointed as an arbitrator. It is, of course, your intelligence, your educations, your expertise, your character, your knowledge, your values. But again, some things might give additional support to you in this field.
Mm-hmm. Thank you so much, Professor Lubna, for this really inspiring story to hear from you. Unfortunately, until now, we are not able to reconnect with Professor Rogers. So I think we'll just move forward, I think, with our questions. And then once she's back, all of us, I'm sure, would love to hear also her story, which I guess when the other day I was talking to her, also a lot of her post-ops included you. So I think that will be an interesting story to listen to. So I think, you know, in continuation of your own novel and experience that you just presented to us, what are the biggest hurdles you have faced as both a lawyer working in arbitration and an arbitrator due to your gender role? And as you said, you know, being an arbitrator or an arbitration lawyer in this field, it's not just about your gender, right? It is about, or in an ideal word, it would have been just about our qualifications, our resume. But as a woman, and I think we've all noticed that, especially maybe as young women, if we enter a place like the ICC or, you know, a high-profile law firm of arbitration, you immediately feel like you need to maybe provide extra work. So deriving from all that context and background, what are the biggest hurdles that you faced for and due to your gender?
Well, to start with, the local hurdles or the local challenges, it might be summarized as there is always a closed club for men in the legal profession, in the arbitration profession, etc., etc. And knowing the number of women arbitrators in Palestine is almost shocking. Just today, this morning, I went through the list of accredited arbitrators from the Ministry of Justice. And among the 140 listed names, there were only 6 women. And that is really very little. And knowing that almost half of them are not practicing, then it's even worse and worse. So it is very common when you are working locally in Palestine to see that the arbitration panel is composed from people knowing each other. But that doesn't mean I have less exposure or less knowledge of these circles, but it is the fact that men do prefer to appoint other men, whether they were arbitrators or whether they were counsels or whether they were the clients. This is a fact that we are dealing with in Palestine, but also I think even worldwide. Uh, to talk about the international practices, I would say I have encountered some hesitation sometimes from the client when it is an international case. When we say it's an international case in arbitration, that means it's considerably a big case compared to the amount of cases or the type of cases that are held locally. So when we are talking about an international arbitration case and your client comes to the firm and then he saw that, yes, it's Lubna, it's not X or Y men who are representing them. To be very frank about it, you might have encountered some hesitation, but then it was fully supported, fully appreciated by the clients when they saw how we proceed with the cases and international arenas and with different international institutions or with different law firms. So to go again through the main challenges I personally had, I don't think there are specific challenges per se for me. For 2 or 3, 4 reasons, I want to really highlight in order for us to know what may compose the challenges for other lawyers to be here. As we said, we have agreed on a bottom line that it's not your gender that really affects. At the end of the day, every party wants an adequate arbitrator to their case. But if you want to go through this field and work in the arbitration arena, then it's a must that you have the sufficient qualification, the expertise, the knowledge, the willing of dedicating your time, your efforts for the arbitration you are responsible for. And I see this matter is lacking amongst young practitioners in Palestine. Also, if you look at the number of young lawyers or young arbitrators and how many of them are progressing in the field of arbitration, it's still very little, very limited. And maybe one of the reasons is they don't have a direct interaction with this field. But still, like you know, well, how many people have did their postgraduate studies in this field or are trying to build a career in this field? The number is still little, and I think it needs a lot of awareness, first of all, awareness and knowledge, and then comes many other things to face and to challenge within this sector.
Indeed, I think your answer have or will lead us to really another question that I wrote down when I was writing my list of questions, which is, you've mentioned something very important: the way we select an arbitrator, right? The way we appoint an arbitrator. So we all know that arbitrator selections usually start with long listing of arbitrators, then shortlisting. And then what is off record is that to move from shortlisting to pick an arbitrator, it's really about some phone calls and personal relationships, which obviously will be riskier for women arbitrators, since patriarchy and the male game in arbitration taking place, or what we call it, the boy circle, will be more difficult to challenge and limit. So In this light, Professor Lubna, how do you think this method of appointment have been affecting women arbitrators, especially in Palestine, that since we have only one arbitral institution, at the moment at least, where a very small group of only male arbitrators are part of it? So, again, I think you've briefly mentioned that point, but to add up to it, maybe to give us more density to this element, how do you think this mechanism of appointing really affects our women arbitrators in Palestine and maybe also in general as well?
Indeed, when you want to appoint an arbitrator, whether internationally or locally, you want to know about that arbitrator. And how do you know about that arbitrator, since the arbitrations lists are available only for accredited institutions or accredited arbitrators in these institutions, but you would not know about individual arbitrators, will become more difficult. If there is an excellent arbitrator in Palestine, for example, who has been doing really well with her arbitrators, how we as a business or legal sector know about this good arbitrator? If these arbitral awards are not published, if the work of this arbitrator has not been seen, and the arbitration sessions have been not in public and confidential. So this is where the challenge comes again. How do we know about good arbitrators, and especially women arbitrators? As you said, it's usually done by phone calls, by connections. Law firms ask other law firms, colleagues ask colleagues. So it depends again at what level you are working. If I'm a bigger law firm, I have access to more and better names. So this means that the tranche of arbitrators appointed by top law firm will be the same circulated and exchanged names almost all the times. While other intermediary or new arbitrators are not heading into the field because their exposure to bigger law firms or to bigger businesses is still yet not there. Having said that, there's something that I really wanted to share from our ICC experience and statistics. Last week, we had a virtual commission meeting of arbitration and ADR at the ICC. And it was very, very interesting to look at the gender statistics specifically. And in these statistics, it was amazingly tremendous or a huge increase in the number of appointed women arbitrators between 2011, 2015, and 2020. So if we compared at least between 2015, the number of appointed women in arbitration as arbitrators was only 11%. In 2020, this increased up to 23.5%. That's more than double the amount of appointments. And it's always said it's easier to double a small number than a bigger number, but at least we see a gradual increase, a substantial increase as we move ahead. What is interesting about it too is that 42% of these women in 2020 were appointed by the parties. This again means that there is increasing confidence by the parties of arbitration to appoint women in their panel as arbitrators. The other 40 was also coming from the court. The court has a very declared position on the diversity of appointments. It reflects that in the secretary, in staff, in the court members, and in the appointments of women, of course. And the 18 remaining came from other appointments. 30% of these women were acting as president to the arbitration panels. 30% of them were acting as sole arbitrators, and the 40 were co-arbitrators. So I think to talk at least at the international arena, it's evident that we are seeing a gradual change and gradual increase. As you said in our small discussion of the record prior to this discussion, that there are many different international initiatives that are supporting women, starting from Arbitral Women, from the Pledge, and from other institutions making specific efforts to promote the role of diversity of women appointments in the arbitration field and in the arbitration panels to go more towards equality and having more and more appointments for women.
That is definitely insightful. And, one of the things when we really study this subject or this topic is parties' appointments of women arbitrators. And, there's a lot of lectures, if you go and watch them online or attend them, really specifically talk about this, is that, in the last, let's say, 10 years, the endeavors of pushing women arbitrators appointments by institutional or arbitral institutions have been at least relatively successful. But when it comes to parties appointment, of course, now that you've mentioned that it has increased, but we also still see that there's a huge, really significant gap between the percentages of electing women arbitrators by, let's say, any institutional arbitral institution, like the ICC, like PIAC, right? Like ICSID, for example. But when we look at the numbers of women arbitrators appointed by parties, it is, again, significantly low. So on that regard, my question really is, after your long experience by now in arbitration, both as a lawyer and an arbitrator, how do you think we will be able to manage really such a micro level point of women arbitrators appointments by parties? Because on that level, I think we're not facing an admin or technical matters where, okay, let's set a quota and let an institution, abide by it. I think we are face to face directly with maybe patriarchy, maybe white supremacists, right? So how do we do that? How do we tackle that? What are the mechanisms and tools that we can, offer and propose for such a dilemma?
Well, probably there should be some serious work about promoting women in arbitration. That's one issue. Parties knowing about excellent women and arbitrators or excellent minds conducting arbitration should be available. And this can be one starting point, is really promoting those good, excellent minds in arbitration for the parties. One other issue is to start a very broad dialogue on about how do parties appoint their arbitrators, and what are the considerations that they should have or take or do when they want to make an arbitration. This dialogue should be on different levels and engaging many different parties, so that it introduces that women arbitrators can be an equally efficient and effective arbitrators as men arbitrators. On another aspect, it is very important that also women arbitrators are seen in the screen, are seen on the screen. That is, they are known by their profession, by their excellence, by their expertise. And probably it has been said that women are less tendent to promote themselves as practitioners and as arbitrators than men. So taking this a step forward through different arbitral institutions, through different mechanisms, might also assist putting good names, excellent professionals in a place where clients or parties to arbitrators can see them really well. Introducing or reporting the cases that has been made by arbitral women or by women in arbitration has been a trend also on from different institutions. For example, one of ICC decisions on this regard is to start to disclose statistics on the arbitration or the women in arbitration, and that was not something that has been done before 2016. So now going through this is giving also an advantage to introduce more panels with women, to introduce more names in the sector, and to introduce statistics, which will help also change the stereotype of clients or parties of women in arbitration. That might be few of many other tools that can be taken, but at the end of the day, as we say, it will not be a very easy matter to take by day or to see the change going in few years. I think the change would take some considerable time. It's going gradual, but it needs really combined efforts from different parties to make the women in arbitration more seen and more selected by the client.
Mm-hmm. I think everything you've proposed and said is indeed very important, and we should reconsider in this field. So again, just to build a concise discussion. So I think my next question will be regarding, again, a mechanism that you've just kind of briefed us on, which is kind of quotas. So do you think setting, for example, quotas in arbitral institutions and centers to accommodate women arbitrators, or let's say shortlisting them for appointment, is an efficient mechanism to use, and that is one that actually reinforces women empowerment and not vice versa? And if yes, then why do you think it has been successful?
I mean, I would go for more shortlisting than a quota in women in having places in arbitral institutions. And nominating them again based on their quality and effectiveness and good knowledge. An arbitrator is an arbitrator for what he represents or what she represents in terms of expertise, and again, as we agreed, not on gender. Starting from this angle, we can go and move forward, maybe also to see why do women have more challenges than men? If we can go and tackle these, I think, as you said correctly, Nawal, at the beginning, it's a different world. What an arbitrator in the US may encounter a challenge may different than what an arbitrator in Kenya or in China or in Brazil may encounter or challenge. So we must see the challenges that such arbitrators, and specifically women arbitrators, are facing in different jurisdictions. Try to cut, sometimes it's a legislative approach, sometimes it's a professional approach from the bar, from the arbitration institutions, sometimes it's academic approach, providing courses in the field, making it available for young professionals who want to educate themselves about this matter, available in the country where they are residing or where they want to continue their education. So there are different really approaches that one should look first at the challenges that are facing such arbitrators or women arbitrators, and then tackle them one by one to make the environment more amenable to women arbitrators to practice and flourish.
I think you mentioned a very vital point, which also later on I wish to discuss. And if Professor Catherine Rogers was with us, it would have further enriched the discussion. But unfortunately, she just texted and said that she has a health situation going on. So, and what you mentioned is that, it is vital, before we discuss the topic of women arbitrators and women in arbitration in general, and why they are so misrepresented in comparison, again, as we said in our introduction, to any other alternative dispute resolution mechanism field, to point out the root and the source of the issue. So where do you think the root of the problem relies in? Is it patriarchy, racism, white supremacists, or the leaky pipeline, which it is technically that women arbitrators have less potential to be appointed because they don't or didn't hold positions as, high profile positions as men arbitrators, like being a partner in a law firm. And the reason that they did not, or let's say were not able to, is due to their gender role. So is it that as well? Or perhaps is it, a colonial mindset, especially when it comes to international arbitral institutions when appointing and electing arbitrators, women arbitrators from, let's say, non-English speaking countries, or what we call now underdeveloped countries. So where is the problem really relies in? Because again, I think when we read about this topic, when we try to tackle it down, rarely do we see someone start from this point, right? And they say, okay, it's not just patriarchy, because this is the only terminology that we can really see in this topic. Perhaps it is this with that, all the kind of examples that I just give. So that might help us to maybe amend the endeavors that we have been offering so long. And there is results, but still, obviously, that we're still holding this conversation. The results are not the way that women arbitrators or women in arbitration wish it to be. So where do you think the root of the problem is?
Well, to look on the roots, or to discuss the roots, I think it's very important, again, to look a little bit on the legal profession per se, and to look at the statistics again. So if I want to give an example based on the statistics from the Palestinian Statistics Bureau, and when I look to the number of women who studies in faculties of law in Palestine, one can easily notice that it is almost 50%. It's a 50% of the students at the law faculties or the graduates are women. But then suddenly, when we go to the practice and to the Bar Association statistics and to the practicing even to the practicing number of lawyers, we see the number fall dramatically. And this means out of the 50%, maybe 40 or 30% decide to continue and have their license to work as lawyers. And then at least it's 20 or 25% of this amount are only practicing lawyers. So from one aspect, I can say that's a decision which I fully understand, respect, and admire. If a woman decides not to practice her profession, and probably like 80% we know because of her role as a wife, as a mother, and this is a choice that, again, I totally understand and respect. But again, there's the other aspect of it, that women are not pursuing this matter proactively as men. So this one of the basic problems at the roots, at the bottom. But if we go further, how much these, for example, the same group of women practitioners who decided to practice and started their career can see or can promote themselves or develop themselves as women in arbitration. Again, for example, in Palestine, there is very limited resources to this field. As we said, I myself have been educated in this in Queen Mary in England. You yourself, Noel, has been educated in Pennsylvania in the US. And now it is more often that there are pure courses at the universities that are teaching arbitration. We can see moot courts competition invading the Palestinian universities, and students and professors participating in them actively. But still, it remains a very limited area of knowledge available in the universities. So again, there's another level of restrictions for these practitioners. If we look at the people working in law firms and looking at how many partners are there in law firms, women partners, how many women who owns their own firms or their own practices, again, the number is very much less and less and less. So as long as we go up the pyramid, or as long as we proceed with how a woman or how a lawyer can develop her profession as an arbitrator, we can see that the road is getting stricter, and it's narrowed down for many different reasons. Again, there are other issues that would affect. We talked about the knowledge, the expertise, but it's also, for example, other issues like language. If I haven't been fluent in my English language, I would have never been able ever to be a part of the international arbitration community. So that's another issue to look at. If I've been not exposed to construction, for example, cases and disputes, and have very good knowledge in FIDIC and FIDIC contracts and the arbitrations, then again, that has been narrowed the way and the progress of my career in this field. So there's a lot of things that are combined all together. It might be different in some other places, but I think we internationally share all these common issues. How much women themselves want to go through this practice, how much it's available for them to have proper education and expertise in this practice. Then in their practice, how much they are promoted as part of the law firm or as part of the practice to be top practitioners in this field, and how much they prove themselves to be excellent candidates to be arbitrators or legal counselors in arbitration. There are a lot of issues. I think if we start with, we can go with a full list. But again, I think it's different from one jurisdiction to another. There might be some peculiarities to another, to some jurisdictions other than others. But as we agreed, also the difference between the notion of only appointing men arbitrators is changing. However, we can't demonize that the number of the pool of men arbitrators is much wider. When I look of pool for the, in Palestine, for example, with 150, and there are only 4 or 5 women arbitrators in it, then it's catastrophic. Then it's something should be done here to have more balance, to promote more legal professionals, to promote more engineers, for example, more accountants, all the professions that are capable of being arbitrators in their fields, to promote themselves, to educate themselves, to have more experience, and to be more also, sometimes it needs also some support to encourage them. Sometimes a person would say, oh, what's that field? I don't know nothing about it. I mean, to tell you the truth, I've seen men arbitrators who are not doing their work really good, while if it was a woman arbitrator, she would have been scammed. So let's give her the benefit of the doubt and support her and introduce her to this field and support her to be an adequate person in a panel, and say that it's not a field that you cannot really work in or excel in. It's a field that you need to know about, to study, to train, to have expertise in, and it's not something that you cannot do.
I see. A lot of what you mentioned is that sometimes women in arbitration, right, they take the first step in their career. And then, as you said, and I think that's what in our introduction we said, the dearth of active women in arbitration, because there is women in arbitration, right, in respective numbers, really. But we don't see, but the issue is we don't see active women in arbitration. And I think, people might say that, well, it's their decision. They don't want to proceed. And I think, at least personally, after studying the scene on this topic, we've seen that the reason why a woman arbitrator, or let's say any woman in arbitration, an expert, emergency arbitrator, whatever her label is, or a lawyer, is due to the hurdles that are put in her way due to her gender, right? It starts from a really early level, before she made it to, let's say, a registered ICC arbitrator, right? When she's just an attorney in a small office working in this field, a woman can see that, her male colleague that working in this field is getting more clients, because again, parties trust maybe males more. So I wanted to add this comment for also other lists, that why women are not really taking further steps. And before, there's a question for you, Professor Lubna, from our audience. But before I head up to that, just to again to proceed in this topic, which is what is the reason that causing the inactivity of women in arbitration? So, within the field or atmosphere of women in arbitration, in your experience, how did you see, as the first arbitrator in Palestine, an IC representative, how did you see race, language, religion, or even perhaps the prestigious academic qualification affect and further discriminate women arbitrators and women in arbitration in general? And do you think that this type of discrimination manifests differently from a jurisdiction to another? Perhaps maybe you have a story or an experience that you would like to share with us on this regard as well.
Well, definitely, it does make a difference from one jurisdiction to another. And the things that one may encounter in specific jurisdiction could be much, much, much different than what can this same person encounter in another jurisdiction. To say frankly, in Palestine, as I said, it has been difficult to become such an arbitrator, except for the hard work that has been conducted. But nevertheless, this has been much recognized and appreciated. The first nomination to ICC came from the Palestinian ICC chapter in Palestine, which was fully dominated by men. All the board of directors for the Palestine chamber of the ICC chamber in Palestine were top businessmen in Palestine, and all of them were really males. But yet, and having been working, all of them with different top law firms in Palestine, where excellent business lawyers have been in direct contact with them, they nevertheless decided to appoint me or to nominate me as the Palestine representative in the ICC. So in general, the gender per se, at least here in Palestine, was not an issue by itself. However, I can see it in many different jurisdictions causes a lot of issues in terms of appointment, in terms of promotion, and in terms of agreeing to have an arbitrator with a woman and with a gender as a woman. Just to brief on this, let's say that arbitration is coming also from a field where you have to deal with so many different legal institutions and arbitral institutions. So sometimes the solution can be also coming from top to bottom, not bottom to top, as we have been advocating since the beginning of this conversation, whereby we are saying education, expertise, training, promotion, etc., etc. How much we see the ICC court is comprised from women, or the PCA court is comprised for women, or different institutions, as you said, mentioned in PAYAC, how many women women are sitting on the board of PAYAC in Palestine is very important. How this reflects from the top of such institutions in themselves, in their own structure, first of all, and then in their appointments, second. This itself will make a huge change and a huge difference of the fact of how women are represented and perceived in each jurisdiction, or internationally or locally. As we have seen also lately in the past 10 years, the London Court of International Arbitration, the different institutions, the Stockholm Arbitration, different institutions are trying extensively to promote the women in their own structure first, in their appointment second, and in their promotion third. So that also is a considered part that we should look to and not ignore when discussing how do we want to see a woman in the arbitration field doing better, promoted better, perceived better. So again, there's a role for all these institutions to play in as well. You're muted, Nawal. I can't hear you.
I said, thank you so much. I think this is definitely, you know, an eye-opening, right? Because usually when we talk about this topic, as you said, we propose mechanisms and methods of, as you said, from the bottom until the top, right? Of how to empower women, of how to activate the role of women in arbitration in general and women arbitrators in specific. But I think also considering or putting some pressure and responsibility on you know, the hierarchy of the pyramid, the tip of the pyramid is also, I think, would be at least directly and externally maybe more efficient. Let's see. So we have a question for you from the audience, and I would like to announce for everyone else who's watching us on YouTube that you can direct your questions right now. We are open for questions. So your question is, I think it's from, I'm going to read it the way it is. It's from Sharik Ahmed, and it says that, Professor Lubna, how do you think that do you think that arbitration is more successful in Palestine as an alternative dispute resolution mechanism more than the traditional adjudication mechanism, which is a judiciary? So I think that is the question. It's an interesting one, indeed.
Yes, definitely. I mean, if there are two things to compare with, one of them is arbitration versus the judicial approach or the courts, the legal, the proper legal system, which is the courts. I say it has been growing tremendously in the past 10, 15 years. The Palestinian courts as a public sector has been encountering a lot of issues similar to any other courts worldwide, starting from backlog of cases, the lack of expertise in specific fields, especially in banking, international commercial trade, construction, and similar fields. So lately, there has been an increase, a huge increase in the number of cases that are referred to arbitration versus to customary judiciary. If we are comparing arbitration as other ADR mechanisms, I must say it's foremost and the only leading choice of the parties, probably because it is a binding mechanism whereby we can see there's a little of mediation, conciliation, or any other similar mechanisms practiced in Palestine. So it is by far the most applicable ADR mechanism in Palestine.
Uh-huh. I think I agree, and you know, this is a whole topic by itself, right? Which is how arbitration in let's say maybe conflicts in zones, right? Or conflict zones. So this is also a topic we've previously spoken on in our center. So which we see that, you know, the activity of arbitration, especially because it's maybe linked to international investment, it is different, right, from another jurisdiction. So
excuse me, I just want to make sure that also in this question, the reference was not made to other mechanisms, traditional mechanisms such as tribal decisions or tribal conciliation or tribal arbitration, because this is also a very common mechanism in Palestine and probably in the Arab world, where many disputes are still settled within the tribal mechanisms, which do have some similarities with the issue of conciliation or arbitration. But to tell the truth, my personal judgment on them, that it's not, when it's not based on pure written, clear, transparent law, I have my personal concerns about it. And when it does not have proper recognition to women, child, minority rights, again, I do have some issues with them. But I've just recently, 2 years ago, also made a small report on ADR versus these tribal mechanisms. They are still considerably practiced in Palestine, and they do have their effect, they do have their role, they do have their legitimacy in the applicable laws. And they were needed at a certain stage when the occupation did not allow full practice of lawyers and courts and judges. However, as I said, this remains also with major concerns that we should not blink an eye on and keep under the radar.
Definitely, indeed, an external element of, let's say occupation or a third party government affecting how arbitrators or anyone in arbitration trying to do their job is also another dimension that we need to study when it comes to this topic, indeed. So another question for you from the audience is, and I'm going to try to rephrase it, is that why do you think that we need to bring the element of gender when we're talking about arbitrators' appointments or women in arbitration in general, not just arbitrators? Why do you think it's important? And I think this is an interesting one because it is really the core of why we're conducting this event, right? So please go ahead.
In many instances, well known that there is an unconscious bias whereby you automatically would just appoint a male arbitrator rather than appointing a female arbitrator with the same skills. I remember reading something when I was preparing for this encounter that Harvard students were given the same CV, one for Howard and one for Hilda, or with the same skills, with the same expertise. And they asked them which one would make a better colleague at work. And indirectly, most of them, at least went towards the male CV rather than the female CV. So we can't undermine this unconscious bias. It's not individual. It's also spread across the attitude of clients, of institutions, of companies. So that is one main aspect. As I said also at the beginning, in many instances, it is very much seen that women arbitrators are working less to promote themselves in this field. So sometimes, yes, you should highlight and say there is a good woman arbitrator in this field because she's not visible there or she's not seen enough there. We do not disagree. The skills are the most important and it is the determining factor when appointing. But there are other aspects that we cannot disregard when we see how arbitrators are appointed. So the gender remains an important part to talk about when we say, if we want to say that we want to have a real diversity or a real parity in the appointments of women.
Thank you so much, Professor Lubna. And I think we have another question also to direct to you from our audience. And this one is also kind of similar to the previous one, which is how successful do you think traditional customary modes in general are successful in Palestine? And I think I would personally add to it, it's a personal question. And what do you think the hurdles are if those mechanisms were not as active as others?
Well, again, traditionally, such mechanisms were very important during the past decades. As I said, Palestine is a country under occupation. The enforcement of law is restricted for so many different reasons. The access to enforcement law in different areas of the Palestinian territories is restricted. Therefore, these traditional mechanisms at a certain stage were very important to give efficient and enforceable decisions in very important issues. And mainly, I will say they were important in issues related to criminal issues when we are talking about a killing, or when we are talking about a raping, or when we are talking about issues of such of coming from the criminal perspective. It is not common in commercial arena. It's not common. It's less common in the civil arena. It might be also important in marital issues related to divorce, marriage, custody, etc., etc. However, nowadays, I think these mechanisms are actually decreasing in the applicability of themselves, of them as mechanisms, or the resort of people to them also from the other aspect. If we look again to the statistics, we see that people would prefer to go to a place where you have a final decision, which is based on a law that is published, transparent, based on equality, or based on at least understanding and maintaining human rights. So I think nowadays these mechanisms are getting less active, less resorted to, and are not being the basis for having dispute resolutions through them.
Yeah, thank you so much. We have another question from actually someone who just texted me on LinkedIn. Her name is Nadia Brassolnes. I hope I'm pronouncing your last name correctly. She's saying she's unable to leave her questions on comments, which is fine. So her question is directed to you, Professor Lubna, and she's saying that, you know, after your experience, your long experience as a lawyer and arbitrator, what's your analyzation of women arbitrators' experience in the MENA region, and not just in Palestine in general? And what do you think some, you know, mechanisms or some tools we can use to, again, re-empower them? And I think in her question, as I look at it now, she's mentioning because some jurisdictions have, you know, the Sharia law, for example, where woman cannot be an arbitrator or a judge. So she kind of also touched base on that. I hope I rephrased your question correctly, Nadia.
Indeed, it is very important to talk about women in the MENA region. And one can say proudly that when you look at some jurisdictions, such as Lebanon, Egypt, Tunisia, there are some brilliant names of women arbitrators who have really made their way and had their path in the arbitration field, and are now well-known, prominent arbitrators, even in the international field, though they still remain a very, very, very tiny percentage of the women in arbitration, whether in the MENA or internationally. While again, you would see that in other jurisdictions, especially as you have correctly noted, probably the Gulf, and not only not the whole Gulf, because in areas like, or in jurisdictions like the Emirates, again, we can see good rising arbitrators. In Bahrain, we can see again excellent arbitrators. But in other jurisdictions, you would see there is a huge restriction and probably a lack of or a very minimal number of women in the arbitration field that are promoted or have been seen to be active in this field. That's due again for so many different reasons. As I said, in the Arab world, it's how much you have access to education in this field, how much you have access to expertise in this field, how many business law firms you have that have a section for arbitration, how many business law firms that have specific expertise for arbitration in oil, in construction, in solar, etc., and that are encouraging women to be a part of it. As you said, in countries like Saudi, it's not only women in arbitration, but also women in legal profession per se. So that is an additional restriction that we should look. We go back to the roots and see how the woman starts in the roads. And as we said, as we go ahead, the road gets narrower and restricted. But I must say, it is not a very bright and rosy picture for women in the MENA region. However, I don't see it also as gloomy. There are good names. There are wonderful women in arbitration in the MENA region that we are really proud of, who have been working in international arbitrations, in ICC and LCIA, and in many different organizations. So I think I'm looking more to the half full portion of the glass rather than the empty one, and looking forward for that to be better and better.
Indeed. And I think, the other day I was also discussing this topic with a colleague, and who happens to be from a let's say, MENA region country. And, we were discussing that patriarchy, or, let's call it the male supremacist, in different jurisdictions, it's not a question of is it less or more. And I think this is very incorrect and blurry perspective to look at it. It is a question of how differently it manifests, right? So, she would share stories of how patriarchy in, I would say the name of the jurisdiction in the US has affected her career as a woman, and like some, terrible stories of her working career in an office affected by male colleagues around her, and how my stories are also different. So I think, again, as you said, I think in the MENA region, we, at least, especially you mentioned like Emirates, Bahrain, they are floral seats of arbitration, right? They're flourishing, they're in that phase, and thus we do see really big names, I might say, of women arbitrators that work on an international level. So yeah, it is indeed a question of how differently it manifests. And that is, I think, something for policymakers, especially international policymakers on this regard, in big arbitral institutions like the ICC, like the LCIA and all that, need to undertake and consider, right? Is that because they are tailoring mechanisms to deal with women who comes from hundreds of jurisdictions, different legal jurisdictions, cultures, language, and all that. So that kind of understanding needs to be there. So I think my last question, I'm just going to give one last call for everyone. If you want to send a question, please go ahead before we wrap our session today. So my question.
Just before you pose your
Yeah.
last question, maybe also adding to what you have mentioned.
Yes, please.
Of women as arbitrators in the MENA, and how different institutions would appoint or recognize such women. It was also interesting with the statistic presentation from the Secretary General of the ICC I mentioned earlier, to see where is the focus of arbitrators' appointment comes from. And if you would look at the MENA region, it would hardly represent like 1% of arbitrators from the MENA. And that is for both men and women, versus a very high percentage from the EU, for example, where it can exceed 40 or 50%. Or other areas like the US, where it can be something around 15%. So it's very interesting to see even that in general, for both men and women arbitrators, the jurisdiction is very important. And this statistics were really dazzling when you look at it. There are areas where like you can see them even on the map. And there are jurisdictions where you can see a number of like 50% from appointed arbitrators are coming from the EC, which means culturally, they have been working on this for more decades than it has been in the MENA region, or than had been in Africa, or in certain parts of Asia. So it's not only, again, a matter that relates to women, it relates to the sector by itself and the jurisdiction itself.
Indeed. And yeah, I think again, this is how we read statistics, right? We cannot be like, okay, 40%, there is 40% women representation in arbitration tribunals in the US, let's say. This is just, an example. And then there's like 2% in Palestine. But then we also need to undertake that, well, it is also because the PIAC, for example, right, which is the arbitral institution, have maybe only 40 in total arbitrators, registered arbitrators, right? Both male and female. So that is also something we need to consider. And so, we would, thank you for all of those enlightened answers and discussion that you gave us. And then I would like to wrap it with one last question, which is, after everything we've discussed so far, is what do you think, in your own experience, in your own journey, both domestically and internationally, whether in the academic field of arbitration or in the practical field of arbitration, what are inadequate mechanisms we should whether further enhance maybe, or add if it's non-existent at all on the table right now?
Well, it should not be necessarily not existing, but from my personal experience, what I thought has been very much influential and giving excellent results is exporting some knowledge and expertise to the region. Through my membership at the ICC, I've been active in participating Young Arbitrators Forum in Palestine and Jordan for the last 10 years. We have at least conducted 4 forums, and whereby we have different experts coming from EU, US, the Arab world, and introduce the young generation to arbitration per se. And this includes definitely women and men. But in my personal opinion, this one main aspect of introducing knowledge and expertise from practitioners directly to people who want to engage in this field and people who want to be practitioner in this field is very much important. As I said, also several initiatives worldwide now, like moot competitions and participation in moot competitions in the Arab region or even worldwide, have been giving some really good results in exposing students, exposing young practitioners to this practice on a regional and international level. So I think such issues from experience, education, would give a very high impact on the development of the arbitration in a specific jurisdiction, and promoting the people who want to work in this field to get better experience and be exposed to this field.
Thank you so much, Professor Lubna. I think again, this is something to consider. One last question from the audience that we just received now, and as he said it himself, it's completely off topic, and I agree. But why not? Let's go ahead and shoot it. So he said that I'm gonna try to rephrase it. What kind of mechanisms and tools we might, as advocates or attorneys or legal personas, use to maybe further advocate the Palestinian case and the human crisis that we are going through? And I think this is an interesting one, because I think I am going to add up to it to kind of link it to our topic. So this is his question, and then mine to build on it would be, how do you think the element of the human crisis that we are going through, the occupation that we're going through at this moment, especially with the latest things that are going on in Jerusalem at this time, how do you think this affects arbitrators and arbitration in general, and specifically women? Do you think this element maybe in some way affects women specifically?
Again, yeah, this is a very important issue to tackle, and maybe to link it more and more to the topic in discussion, I want to refer to a pilot initiative that took place several years ago in terms of trying to mitigate the political situation and promote business relationships in the Palestinian context. As you're well aware, there have been an initiative from the ICC in Paris, which is rarely to happen, to establish an ICC-based arbitration center outside of Paris. This is available in Singapore and in another place, but due to the huge amount of cases and different languages, traditions, legal traditions they're in. But in Palestine, it's something different. This initiative is about establishing the Jerusalem Arbitration Center, which was supposedly based to provide arbitration between Palestinian and Israeli parties to settle them in this institution. And again, this will reflect the actual situation that we are in, that the Palestinian-Israeli conflict is not only about having appropriate venues or mechanisms to settle the dispute, it's more about really resolving the dispute itself substantially in accordance with the international law, in accordance with the right of the Palestinian people, and in accordance with what human rights and a fair application of human rights and international law on the ground would resolve in. The JAC, unfortunately, did not succeed for so many different reasons. For example, if we're talking about Jerusalem, it was situated in East Jerusalem, which is an occupied territory in accordance with the international law. However, it is under the de facto and de jure Israeli sovereignty. So it was very complex. If the JAC issued an international, if the JAC, it was agreed, for example, in the JAC to issue the decisions in Paris, so it's an international award. However, within the process, if the arbitrator sitting in East Jerusalem needed the assistance of the court, which court it would be? And that again puts you on the whole context of the conflict in Palestine and in Jerusalem per se. It's not only about how do I go to the competent court, is it the Israeli court or the Palestinian court? But actually, it's the substantial definition of East Jerusalem, of sovereignty on this particular piece of land. So I think there's a lot to be done in advocating the rights of Palestinian people, in advocating women in arbitration under occupation. But then again, that's a long chat to be taken.
Yes, definitely. This is a whole different topic that we can literally host lectures, I think, series of lectures on it. And, you know, the CEDR actually tried and took an initiative on this topic 2 weeks ago to discuss arbitration in conflict zones and all the different dimensions and aspects that we really can tackle this. And I don't think even one lecture was sufficient, really. So I think this is it for now. We have not received any further questions from our audience. Thank you so much, Professor Lubna, for attending today and you know, enlightening us with your experience. And as I said before, I think this is again an added element we need to underline with this topic, which is race and different cultural background of women arbitrators. So this is definitely important, and we do apologize for everyone that we were not able to accommodate or host Professor Rogers today due to an illness she had to go through, or else we would have maybe witnessed more interactive discussion with, you know, arbitrators coming from different jurisdictions and who actually happen to work on the same project. So the JAC, just for our audience, to give them a background, both arbitrator Lubna and also Catherine Rogers have worked on. So you know, that also would have been wonderful, maybe for next time. So thank you again, and thank you everyone for attending and being interactive with us. Have a good night.
Thank you so much. Thank you, Professor Lubna. This was amazing.
It was my pleasure.
And thank you, Noel, for arranging for this to happen. This was
great.
Of course.
I would just hope Professor Rogers would be well.
Yes,
And
truly. I hope she's okay
Let's hope
and
so.
she's not struggling too much.
yeah, I
Let's hope
she's.
so. Yes.
Thank you very much. It was a pleasure, and I do hope that you continue with these very successful encounters. And
We hope you
it's-
agree to get hosted by us again.
Yes.
inshallah.
We wish.